If you're holding two passports right now, or you're seriously thinking about applying for a second one, I need you to pause for a moment and really focus. Because February 2026 is not just bringing a small policy update, it's bringing a fundamental shift in how the United States views dual citizenship. And the changes on the table could affect your taxes, your passport, your career options, your security clearance, and in extreme situations, even how your allegiance is legally interpreted. This isn't hype. This isn't speculation pulled from social media threads. These are structural changes that could impact millions of Americans living abroad and millions more who maintain strong ties to another country. By the end of this video, you're going to understand what's changing, why it matters, and exactly what steps you need to take right now to protect yourself. Stay with me, because missing this could cost you financially, professionally, and legally. If you're new here, this channel exists for one reason: to break down complex U.S. immigration and citizenship policy into clear, practical guidance you can actually use. We cut through confusion and give you real-world implications. No panic, no politics, just facts and strategy. And today's topic is urgent. For decades, the United States has had what can only be described as a complicated relationship with dual citizenship. Officially, the U.S. government has always preferred single allegiance. The language has been clear: loyalty to the United States above all else. But in practice, the government tolerated dual nationality. Millions of Americans were born with two passports. Others naturalized as U.S. citizens and kept their original citizenship. And while the oath of allegiance includes language about renouncing foreign allegiances, enforcement has historically been limited. People kept their foreign passports. They traveled on them, they owned property overseas, they ran businesses abroad, and life went on. A child born in the United States to one American parent and one foreign national often automatically receives dual citizenship at birth. That child could grow up studying in one country, working in another, holding two passports, accessing two systems, and navigating both worlds without serious federal interference. Naturalized citizens took an oath declaring loyalty to the United States, but they were rarely required to physically surrender foreign passports or formally renounce their previous nationality. That practical flexibility created a global American class. Millions of people built international lives. They bought homes abroad, opened foreign bank accounts, invested in overseas businesses, maintained retirement accounts outside the U.S., and they assumed the framework would remain stable. But as February 2026 approaches, that flexibility is tightening. The U.S. government has announced a sweeping policy overhaul affecting dual citizens. The motivations are clear: national security concerns, tax enforcement, and international financial transparency. Let's start with taxation, because this is where most people will feel the impact first. The United States is one of the only countries in the world that taxes based on citizenship, not residency. That means if you're a U.S. citizen living in Tokyo, London, Dubai, or Sao Paulo, you are still required to file U.S. tax returns and report your worldwide income. Through FATCA, the Foreign Account Tax Compliance Act, foreign financial institutions already report American account holders to the IRS, but beginning in 2026, enforcement and reporting requirements are expanding. The Internal Revenue Service is increasing disclosure requirements on foreign assets, not just bank accounts. We're talking about foreign stocks, bonds, retirement accounts, real estate holdings, business ownership interests, and trust structures. Thresholds for reporting are being lowered in certain categories. Forms are being revised to demand more granular information. The burden of proof is shifting more heavily onto the taxpayer. And here's what matters: penalties are becoming less flexible. In the past, if you made an honest mistake on foreign asset reporting, penalties could sometimes be negotiated. Under the new framework, automatic fines may apply for incomplete or missing disclosures. Even technical errors could trigger serious consequences. Through expanded data sharing agreements, the IRS will often know about your foreign accounts before you report them. Discrepancies will raise red flags immediately. For dual citizens, casual compliance is no longer an option. Every foreign account must be documented, every overseas property accurately reported, every investment disclosed correctly, and this changes financial planning entirely. A tax efficient strategy in one country may create compliance problems in the United States. Retirement accounts abroad can be treated differently under U.S. law. Certain foreign mutual funds can trigger complex reporting rules. This is no longer a DIY situation. International tax specialists are becoming essential. Now let's move to passports. The DRON's U.S. Department of State, being which oversees passport issuance, is introducing enhanced verification protocols for dual citizens. Previously, renewing a U.S. passport was relatively straightforward. Submit your application, documentation, fee, and receive your passport within standard processing times. Starting in 2026, dual citizens may face additional scrutiny. Applicants could be asked to provide multiple years of U.S. tax filings to demonstrate compliance. Proof of ongoing ties to the United States may be requested. Property ownership, rental agreements, employment records, or evidence of economic connections. If your second passport is from a country considered high risk or diplomatically sensitive, expect even deeper review. Processing times may increase significantly. Renewals that once took weeks could stretch into months if additional review is triggered. This means you cannot wait until your passport is about to expire. Planning ahead becomes critical. Now let's address something more sensitive: allegiance. The naturalization oath has always required renouncing foreign allegiances in principle. However, enforcement has traditionally focused on conduct rather than paperwork. The updated policy strengthens the interpretation of exclusive loyalty to the United States. To be clear, the government is not automatically forcing dual citizens to renounce foreign citizenship. That would face immediate legal challenges. But it does create firmer legal grounds for scrutiny if a dual citizen is seen as acting in ways that conflict with U.S. national interests. If someone actively works for a foreign intelligence service, serves in a foreign government in direct opposition to U.S. policy, or engages in activities that materially support adversarial governments, the risk of formal review increases. In extreme cases, denaturalization proceedings could theoretically occur if the government believes allegiance obligations were violated. This is not about cultural ties or visiting family. It's about activities that could be interpreted as conflicting loyalties. For individuals born with dual citizenship, the oath changes don't apply directly, but increased oversight does. Background checks for sensitive federal positions are expanding. Applicants for roles in national security, defense, intelligence, or diplomacy should expect deeper vetting. Investigators may review travel patterns, foreign assets, family ties abroad, and financial connections. Dual citizenship will not automatically disqualify you, but transparency will be mandatory. The United States Department of Defense is also reviewing policies affecting dual citizens in military service. New rules may limit certain deployments or intelligence assignments if an individual's second nationality is tied to a region of geopolitical tension. These policies are framed around risk mitigation, not questioning patriotism, but they could affect career trajectories. Now let's talk about political rights. Dual citizens retain the right to vote in U.S. elections. That is not changing. However, at state levels, there is growing debate about whether dual citizens should be eligible for certain public offices involving national security or classified information. These proposals are not yet federal law, and constitutional challenges would likely follow. But the conversation itself signals a shift in climate. So what do you do? First, rely only on official sources for updates. Monitor the U.S. Citizenship and Immigration Services for immigration changes. Watch the State Department for passport updates. Follow the IRS for tax guidance. Second, hire professionals. An immigration attorney experienced in dual nationality matters. An international tax specialist who understands both U.S. law and your other country's tax system. The cost of expert advice is small compared to penalties for non-compliance. Third, organize your documentation. Keep copies of current and expired passports, birth certificates, naturalization certificates, tax returns for at least 7 years, records of foreign bank accounts, property, and business interests. Maintain evidence of U.S. ties, leases, mortgages, employment records, bank statements. If scrutiny increases, documentation becomes your shield. Fourth, if you are considering acquiring dual citizenship in the future, slow down and evaluate carefully. Dual nationality has benefits: travel freedom, business access, cultural connection, education and healthcare opportunities in some countries. But the compliance burden is rising. Tax complexity is increasing. Career limitations in certain federal sectors may expand. For some, the benefits will still outweigh the costs. For others, the calculus may shift. This is not about fear, it's about strategy. Dual citizenship is no longer a passive status, it's an active responsibility. The global environment is changing. Geopolitical tensions are higher. Financial transparency is expanding worldwide. Governments are tightening oversight. If you hold two passports, you are operating at the intersection of two legal systems. That requires awareness and precision. Here's the bottom line. February 2026 marks the end of an era of relaxed dual citizenship oversight. Enforcement is increasing. Reporting requirements are expanding. Allegiance standards are being clarified. Vetting processes are deepening. But informed individuals are not powerless. You can prepare, you can document, you can consult professionals, you can structure your finances properly, you can maintain compliance and protect your status. Do not wait for a penalty notice. Do not wait for a passport delay. Do not assume old rules will quietly continue. If this video helped you understand what's coming, stay connected. These policies will continue evolving, and staying informed is your greatest protection. Dual citizenship can still be a powerful advantage. But in 2026 and beyond, it demands attention, discipline, and strategy. The world is becoming more interconnected and more regulated at the same time. Make sure you're on the right side of both.